Ms. Collins, whenever you're settled, we're ready for you.
Thank you, Your Honor, and may it please the court. This is a case involving the emergency removal of a 4-year-old by the Texas Department of Family and Protective Services. And the district court erred in denying defendants qualified immunity because none of the defendants violated RB or Bank's constitutional rights. The district court analyzed the investigator's emergency removal under an inappropriate and heightened standard, focusing solely on what the investigators saw on the day of removal, rather than the totality of the circumstances known to those investigators based on their investigation in the days leading up to the removal. The district court also failed to engage in a meaningful way with the Gates test governing exigent circumstances. And finally, even if the district court was correct that a constitutional violation may have occurred, the district court erred because there was no case clearly establishing to the appropriate degree of particularity that the removal was unconstitutional, such that every reasonable investigator in defendant's shoes would have known that their conduct was unlawful. So turning first to the constitutional violation. Again, the district court failed to consider the totality of the circumstances known to the investigators at the time of the removal, which gave rise to a reasonable belief that the child was in imminent danger.
Well, the investigators knew that this was an anonymous report, correct?
That is correct.
It wasn't corroborated by anybody else, correct?
I would dispute that. Some of the overarching concerns of that initial report, being that the child was being exposed to drugs and violence in the home, were corroborated by the district's attorney's office and other law enforcement.
Investigators arrived. Banks denied, of course, that her son was exposed to illegal drugs.
She denies knowing of him being exposed to illegal drugs, but also admits that she was regularly leaving the child in the care of her mother and her mother's boyfriend, who are both admittedly meth addicts.
Banks tested negative for drugs herself, correct?
That is correct.
When the investigators arrived at the house, her son was playing in an age-appropriate manner, correct?
That is correct, under the supervision of, again, Banks's mother, Shirley, and the boyfriend, Justin, both admitted meth addicts with histories of domestic violence, very recent domestic violence. And if I may interject, what the court and the district court overlooked was what these investigators learned late Friday afternoon from the district attorney's office. You won't see it in the district court's order, but it is these facts are undisputed. They're summarized in the incident report and the investigators' affidavits. They have not been disputed by plaintiff with any record evidence, and their legal significance is appropriate for this court to consider. Now, on that afternoon, around 2:20, they received their first call from the district attorney's office. During that first phone call, they learned that Ms. Banks had been arrested the prior afternoon, which is why she had not brought the child in for an assessment as she said she would, presumably. They also learned, again, these are the two investigators, they are learning from the DA that there have been multiple instances of domestic violence between Justin and Shirley beyond just the one major incident that Banks herself had been at the courthouse testifying about. And this is an event where her child is home alone with Justin and Shirley. They get in a domestic dispute, and Banks is on the phone telling her 4-year-old to hide in the bedroom and lock the door to keep himself safe. Again, this late Friday afternoon, these investigators learned from the DA that both Justin and Shirley are using methamphetamines. They also learned that just that Monday, Miss Banks herself was involved in a physical altercation at the home brought on by Miss Banks inviting women to the house to fight while the child was present. So all of this is to say that on Friday, they learn a lot of very concerning information about this child's circumstances and neglectful supervision late in the afternoon, if not in the evening, directly from the DA's office. No one can find Miss Banks or the child. And at this point, the investigators have not been able to lay eyes on him. Not until that Sunday, when they find him in the care of 2 meth addicts who they now have every reason to believe have very violent tendencies. And when Miss Banks does arrive, she cannot identify a suitable placement for the child temporarily. Therefore, an emergency removal is undertaken. And these totality of the circumstances feeds into the district court's second error. And that's that it doesn't analyze these circumstances using the Gates factors as modified for child endangerment cases in Wernicke. And when the totality of these circumstances, again, these undisputed facts, are considered under those factors, exigent circumstances do exist as a matter of law. And there was no constitutional violation by the removal of the child in this instance. And I'm happy to go over any of those factors that the court is interested in. I did want to highlight for the court the nature of the danger facing the child. Again, this is a small child that the investigators reasonably believe to be at risk of imminent neglect and physical harm as a result of that neglect. He was 4. He needs supervision. He needs someone to help care for his basic needs. And those needs are not being met when he is hiding in his room to escape fighting adults. And those needs are not being met when he is being left in the care of drug addicts with known violent tendencies. And those needs are not being met when he is living in a home that Miss Banks herself admits often has over 20 people residing there, many of whom have, per the DA's office, have criminal records and drug addictions.
Can you flesh out for me this error for the district court to consider the DFPS internal removal policies?
Oh, I don't think it was proper at all, and I think the case law in this circuit is abundantly clear that, a violation of a policy is not a clearly established violation of law. In fact, this court in Wernicke, this court in Wernicke cautioned against holding DFPS workers liable based on that same policy because DFPS should not be penalized for exercising prudence in enacting procedures that offer greater protection than the constitutional minimum.
Just so I'm clear, so is your argument that it was improper or not improper for?
It was completely improper for the district court to rely upon those policies as further evidence, or in his mind, the most evidence that there was a violation of clearly established law in this instance.
I'm thinking back to 2002, the Supreme Court's decision in Hope v. Pelzer about obvious constitutional violations, but the court there said it was completely fine for the lower court to look at a DOJ report, for example, about the unconstitutionality of certain practices, because that DOJ report helped show that the right was clearly established. So there you've got the Supreme Court saying it's fine for lower courts to review sort of internal government reports because it goes to whether the right was clearly established or not.
So again, I'd go to Wernicke, which was 2016, where this circuit explicitly addressed this very policy and said that it should not be used to show a clearly established violation of law. But additionally, quite a bit has changed since that Hope v. Pelzer opinion. And I think it's an argument that the plaintiffs grasp onto and that the district court did as well. But this court recently addressed it in Salazar v. Molina. And that's this notion that law can be clearly established despite notable factual distinctions between the precedent relied on and the case then before the court. And this court in Salazar held while that statement might be true in an obvious case, in all other cases, a defendant is entitled to qualified immunity unless existing precedent squarely governs the specific facts at issue. A plaintiff must identify precedent placing the constitutional question beyond debate, such that the answer would immediately be apparent to every reasonable officer. And that's citing the Supreme Court's decision in Casella. And Gates was what the district court and the plaintiff had relied upon here as clearly establishing a constitutional violation. But Gates does not squarely govern these facts.
Did the investigators have any evidence that I guess it's the grandmother and her partner were high on methamphetamine that the child was taken from the home?
The record does not reflect that.
And alternatively, it does not reflect that. Do you have any case law that says the past history of drug use necessarily means that or sort of justifies the child being taken from the home under exigent circumstances, if there was no evidence that they were high on methamphetamine on the date that the child was taken?
So I'm going to quibble with you a little bit, because at the time of the removal, Justin, who is the boyfriend, does admit to the investigator that that both he and Shirley are currently addicted to methamphetamines, and it is ruining their lives.
Addicted
So,
to methamphetamine?
yes.
I think
Now, I'm not saying he's high. Yes. But to your point of a case holding that exposure to illegal drugs or past drug use is enough, this court addressed a scenario like that in Pate v. Harbors, which is an unpublished opinion. And there, this court affirmed the district court's holding that the caseworker's actions were not unreasonable because clearly established law did not address emergency.
There was a failed drug test in that case, was it not?
There's a little bit of debate on that, which I think my opposing counsel can speak to, and that's that there was a positive oral swab for amphetamines. She had admitted to recent marijuana use. I think there was some quabble there about the reliability of that oral swab, but that case was decided at the motion to dismiss stage. But what the court went on to hold was that there was no clearly established law addressing exposure to illegal drugs and being left in the care of an inappropriate caregiver, particularly when the parent's mental instability was at issue. And in that case, the district court recognized that present and past drug use alone may not be sufficient to rise to the level of an exigency. But when coupled with information suggesting the mother's compromised judgment, there were exigent circumstances that the child might be in imminent danger of neglect. We're faced with very similar circumstances here. We have present and or past drug use by caregivers. We have Banks leaving the child with inappropriate caregivers, being Shirley, who, by the way, Ms. Banks had been told in a prior CPS case was not a suitable caregiver for this child, as well as Justin. And we also have a demonstration of Ms. Banks' compromised judgment in the form of her own violent tendencies and leaving her child with drug addicts with violent tendencies. Now, I see my time is about to expire, so I do want to touch very quickly on supervisory liability. The district court here denied qualified immunity to 2 supervisors, even though it admitted that these supervisors had no ultimate authority to order the emergency removal. Almost identical circumstances were addressed in Wernicke. There, as in here, the supervisors were essentially acting as conduits of information from the investigator to the person making the decision on removal, which is, by policy, a program director. The same is occurring here. We have an investigator calling the supervisor helping them get in contact with the program director or a DA, being on a phone call. But that decision is not being made by the supervisor. The decision is being made by the program director based on information from the investigators. Here, just as in Wernicke, that does not amount to supervisory liability, and therefore these supervisors, both Mr. Matchett and Ms. Juarez, should be entitled to qualified immunity.
With regard to Matchett, or did you only appeal with regard to Juarez?
I believe they were both appealed. I will admit that I don't think it was well addressed within the briefing as to Matchett. In particular as to Matchett, because it wasn't well briefed, he had less involvement than Juarez. His only involvement was to be generally apprised of the case. And on the day of removal, he's called to say no suitable placement has been found. He says proceed with the removal process, and that involved calling the program director. And both investigators testified via affidavit that they did in fact call the program director on that day for approval of the removal. Thank you.
Thank you, Ms. Collins. We'll see you back on rebuttal in a few minutes. The court will now hear, is it Mr. Clover or Clover? Clover, all right. Mr. Clover, take it away.
May it please the court, my name is Josh Clover, and I'm here representing Ms. Banks, and I believe actually what's left here is her and her capacity as next friend to RB. Ms. Banks, her individual claims went away on an earlier motion to dismiss, if I recall this case correctly. I wanted to address a couple of things I think are important to address that the appellant talked about here. One of those is, and I think as a starting point, it's important to be clear as the appellee in this case, and I'm so used to being the appellant on these qualified immunity cases, so I apologize if I say it wrong, but we're so used to want to make it clear that it's not the appellee's argument that any of the things or the facts that you heard here today are good or make her a good parent, or things that do not rise to the level of involving the Department of Child and Protective Services in the state of Texas. I would concede those right off the bat. What we're here for, though, is very distinctly the issue of when does conduct or lack of conduct or things that occur to a child or that a parent does or allows to happen to a child, or sometimes we say that the parent doesn't protect the child, when does that arise to the narrow issue, or what the court has in the past said should be a narrow issue, when does that arise to the narrow case in which the state of Texas may take a child from the parents without either the consent of the parent or a court order? And I would remind the court, and we don't talk about this enough in the briefing, but it is talked about some in my brief, but I'd remind the court, and this is part of CPS policy as well in the state of Texas, that there are a vast number of other lesser means that allow the department to become involved in a child and a parent's life short of a removal without a court order or without parental consent. They could have, and I think it's important in this case in particular because, as you're aware, this investigation went on to the extent that there was any investigation when they first received a call 10 days before they removed the child. They removed the child on the 11th day, I think, if I'm counting correctly. They received a call. It was on a Friday. It wasn't assigned to an investigator until that following Wednesday. The investigator at that point meets Ms. Banks at the courthouse in the lobby, according to their own declarations, of the very same court that was in session, presumably, because it was there for a grand jury, at which, if the department had determined that indeed, hey, we need to do something to protect this child, after talking to Ms. Banks, could have easily gone to that courtroom and sought that protection. Could have sought even emergency protection with the court order that's allowed for under the Texas Family Code as well. It's right sandwiched in there between without a court order and just a normal suit for protection. The argument today that there was some, and let me back up. Remember what Ms. Banks conceded to on that Wednesday. There were lots of allegations that came in uncorroborated from an anonymous source the prior Friday, but she conceded to, yes, there are sometimes people in my home that use drugs. Yes, there are people that have used methamphetamine. She denied that she herself had ever hit her child. If that was enough to remove, which is basically the substance of what we just heard, if that was enough to remove the child without a court order on the following Sunday, 5 days later, then certainly it was enough to go into court on that day or on Thursday or on Friday to go ask the state court for relief as it's allowed for under the Texas Family Code, and then we would never be here in front of this court
The only
today.
additional thing I heard was that maybe the Friday telephone call gave them some information about domestic violence that was also going on.
And I'm glad you reminded me of that, Your Honor. And I think it's important that for the purposes of this and recognizing how this matter came before you from a summary judgment proceeding is that, again, there were allegations, and maybe lots of allegations, and those are allegations at that point, and an allegation of domestic abuse, but that was certainly something that wasn't established in a fact. And more importantly, to that point as to how important the state may or may not have felt that that was at that time, if you go through and read the declarations from Williams, or from, if I get this right, from Williams and Herbrich in particular, the two that were involved in the removal, their declarations attached to their summary judgment are a lot fuzzier about what it was that they learned that day from the district attorney. I would argue that even if that was the case, there is certainly no attempt made. I mean, they could have, if nothing else, filed the suit that Friday. I mean, they didn't say they found out after hours. It was in the middle of the afternoon. And I won't go into the record of how that courthouse is arranged, but it is possible. But again, and I think that's another point to bear in mind, is this, like so many of these cases where there's removal of a child, there's always lots of allegations. But here, there's none of them are corroborated by anybody other than what Miss Banks admitted to. I think if I brought Miss Banks here today, she'd stand in front of the court and say she's not Mom of the Year. There's no doubt about that. And as it later became the case that there was a suit for protection of the child later filed that following Monday, certainly CPS, at the rate things were going, was maybe going to become involved with her life. But that doesn't mean that it was proper to, even with all these facts that were alleged at that time, that are those allegations that were in the heads of Williams and Herbrich at the time of removal, that was part of the purpose of the Gates opinion in particular, and Wernicke as well, to leave those, give those social workers that work for CPS, to give them the guidance they need to know when they could remove a child without a court order. And at that time, there was, and the Gates opinion is crystal clear on this, there was no imminent danger of sexual or physical abuse. Much of what's, and this is a distinction we haven't talked about, and frankly, I'm not sure either side briefed it well, but the Gates opinion and the policy that comes from it, and I'll speak to that in a moment, the Gates opinion allows for the removal of a child without parental consent or a court order in the case of exigent circumstances. Well, the question then becomes, all right, great, what's an exigent circumstance? Well, the Gates opinion tells us that as well. And it says that an exigent circumstance exists or is present when the child is in imminent danger, meaning danger right in front of the investigator's eyes, or if they were to leave right away, in imminent danger of physical or sexual abuse, not mere neglect. And those are sometimes a distinction without a difference at the state court level, but it is a distinction in some of the Texas Family Code, and certainly a distinction in Gates. And more importantly to this case, it is certainly a distinction within the internal policy of CPS. Now, I understand and I know the law, and I would concede that CPS policy is not the law. The law is right now what the Fifth Circuit says the law is. The law is what Texas statutes say the law is. However, in this case, we don't have the problem that Wernicke warns us of, about looking at internal policy and treating that like the law and holding public officials to those standards. Because at least in my estimation of it, and I've read it and I leave it to the court to read, all the internal policies are in the appellate record here. There's nothing in the Gates memo, as it's sort of known, there's nothing in the Gates memo that affords greater protection than what the Gates case says. It doesn't say you need super exigent circumstances or something like that, or it doesn't say you have to have a court order, even though the Gates opinion says you could remove with exigent circumstances. That internal, all of this, whether it's the CPS handbook, which is in the appellate record, or whether it's the Gates memo that attorneys like me rely on so much because it's called the Gates memo, none of those go further than what I consider to be the state of the law in the Fifth Circuit, at least on that is. So why then do I think it's important, at least, or you hear attorneys like me argue about it, is it's important because I think that CPS policy gives some indication of what they understand as reasonable social workers in those positions, what they should do in various scenarios that they find themselves in. There's no doubt that neither the Fifth Circuit nor any court can address every factual scenario they may occur, but the Gates memo certainly gives an indication that the Gates opinion gave us a standard that's workable for cases like this. One of the complaints that the appellants have in their brief, at least, particularly in their reply brief, is that, well, the right wasn't clearly established. And I'll let the court figure out, we quibbled back and forth on, well, was that really raised in the summary judgment or not? The fact of the matter is we're here, and I argued it both ways in my brief as well as they did. But the fact of the matter is that I don't know what else the Fifth Circuit would do in a case like this. If the Fifth Circuit, if the court were to say, well, Mr. Clover, you're wrong, but I don't think that quite gets there, so they have immunity in this case. And then if the circuit were to then pronounce, okay, here's what the rule is for that case, I don't know what, and everyone here is far smarter than me, I will grant that, but I can't imagine, after having dealt with some of these cases, what that rule would look like, what else the court could say other than that if there's not exigent circumstances or a court order of parental consent, the state doesn't get to remove a child from a parent. That seems to be a fairly simple rule, a workable rule. It's certainly a clearly established rule, and I can't think of how you would make it more specific to a case such as this. And unless the court has something further for me.
Just a quick question
Yes, Your Honor.
on the supervisor. So Warnicki, some would argue pretty similar facts, and in Warnicki, we held the supervisor was entitled to qualified immunity, again, on pretty similar facts. And why wouldn't Warnicki control here?
As to the supervisors, I would agree Warnicki's the law. The supervisors are conceitedly a tougher case for me, and frankly, a little surprised we made it through summary judgment with both of them. I would point out here that as to Matchett, though, Matchett was, whereas Juarez was the supervisor involved from the time that the intake came in and was apparently, if you read the declarations, the direct supervisor of Williams. She conceitedly sent Williams and Herbrich to go meet with the DA on that Friday afternoon to figure out, go let the DA decide if we can make an emergency removal. And I concede those facts such as they are. That's what's in her declaration, and we don't have any reason to dispute that. Matchett, on the other hand, was the one who was directly involved on Sunday afternoon and heard from her investigators that were out here. We found the child. Mom wasn't here right away. The child was playing in the front yard under some adult supervision. We may have some concerns about that adult, but at least the adult appears to be appropriately supervising the child now. And this is what always comes up in these cases. And when Mom showed up, she could not provide an alternative appropriate placement for the child. And Matchett says, by all accounts, approves the removal at that point. So I do think there's some distinction between the roles these two supervisors played here.
Okay.
Thank you very much.
Appreciate it. Thank you. Ms. Collins, we'll hear from you on rebuttal.
Thank you. This case is a close call. And what we learned from Warnicki and the unpublished opinion in Pate is that neglectful supervision of a small child places that child in imminent danger of physical harm. That's the exigent circumstance. And here,
My only issue, what I'm trying to bridge the gap on is it seems like what you're saying is the negligent supervision is based on the history of these folks. Like I didn't see anything on the day of the incident, on the day of the removal, that added to anything that you already had knowledge of. And as the appellee has stated, the additional information came to you midday on Friday, and any number of things could have happened between 2:30 and 5 o'clock on Friday that didn't happen. And I don't know anything additional that you learned between that time and Sunday.
so the calls with the DA's office start at 2:20. There's a series of 3 of them. There's intermittent calls in between with a program director. So we're not talking about something that happened over the course of 30 minutes. During those calls, that's when they learn of Shirley, we'll call her the grandmother's, own history with CPS, that the parent has already been told, being Ms. Banks, that Shirley is not an appropriate caregiver for this child. She's been told that by DFPS. That's when they learn about the concerns of methamphetamine use by both Justin and Shirley. That's when they learn of additional domestic violence between the 2 of them that had not been disclosed by Ms. Banks. It's also when they learn about Ms. Banks' own violent tendencies, that she's inviting people to the house to get in a brawl in front of her child, or with her child present at the home. So that's the neglectful supervision, and those are the circumstances that brought it to the level of an exigent circumstance. And now the exact time of when that last call with the DA occurred, we don't know. It had to have been late in the afternoon on Friday, and the call is made, well, a placement, a child safety placement could be appropriate here. We haven't been able to lay eyes on this child. We've barely been able to speak with Ms. Banks. She's been avoiding our phone calls. Let's try for that placement. And if that doesn't work, and we're in the circumstance which we wound up in, being it's a weekend, then you can call the program director to get approval of an emergency removal. And that's what occurred here. Supervisor Matchett did not have the authority to approve that removal. Both investigators' affidavits reflect that the program director was contacted and approved the removal because no suitable placement could be found. And that goes a bit to what Counsel was talking about. Imminent danger doesn't mean that you see the parent hitting the child. That's immediate, but the standard here is imminent, and that means threatening, right? And here,
Imminent means threatening?
Black's Law Dictionary, one of the definitions of imminent is threatening, yes. And here, common sense dictates that it was not safe to leave RB on a Sunday afternoon with Justin, Shirley, and Banks, and simply hope for the best. Rolling the dice that this child will still be there the next day, because again, this parent has given 3 different residential addresses to law enforcement at this point, and they have been looking for this child for 4 days and are not able to find him or assess him during that entire time period. But essentially, let's roll the dice, hope that he's at the home, and let's hope that he is not neglected or harmed in the time it takes us to go to court and get that order because she cannot find a suitable placement. And in these close calls, the state acts reasonably by erring on the side of protecting the child. And maybe the defendants made the wrong call here, but they're still protected by qualified immunity, even if that is the case. Qualified immunity provides officials with breathing room to make reasonable but mistaken judgments, protecting all but the plainly incompetent or those who knowingly violate the law. And I'd submit on this record that no one knowingly violated the law here. And with that, if the court has no other questions, we would ask that the court reverse the district court's decision and find that each of these defendants is entitled to qualified immunity as a matter of law. Thank you.
Thank you, Ms. Collins. The case is submitted. That's the end of our 2 cases today. Professor, are y'all in a hurry to get anywhere? Do y'all have to leave right away? We're going to go back here and hang up our robes and talk for a spell, but I'm happy to come back out and spend some time with your students if there's any interest. No pressure. All right, I don't know how long it'll be. Could be 15 minutes, could be longer, but I'll pop back out as quickly as I'm able. All right, enjoy.